Now turn to the fourth case on this morning's docket. Case number 111401, State of Kansas v. Gregory Neese.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers and respectfully requests 3 minutes for rebuttal.
3 minutes is granted.
If you believe everything I just said in Rice, then we should be fine here. If you don't, we can still win because we can rely on a different exception. Consent is no longer needed. Search incident to arrest is. There was a lawful search incident to arrest in this case. Neese was arrested. He was lawfully arrested. That has not been contested in this appeal. And Birchfield makes it clear that under a search incident to arrest, the evidence comes in. There's absolutely no reason to apply the exclusionary rule in this case. The arrest was valid, there was no violation of the state statute, and there was no violation of the Constitution. Thus, the evidence in this case should not have been suppressed, and the case should be remanded for further proceedings.
Was search incident to the arrest ever the theory that was preserved?
Your Honor, no, it was not argued below. We did argue that it was permitted as a Fourth Amendment search, but didn't specifically say search incident to arrest. But I think in light of Birchfield and the intervening change of law, I think previous counsel in Rice was right about how I'm not sure anyone foresaw that blood and breath were going to be treated differently. And certainly the state and the defense have never argued that way. So we have an intervening change of circumstance that Birchfield tells us now that this is a lawful search. And there's just no reason to apply the exclusionary rule here. The exclusionary rule is to deter unlawful conduct, and none occurred here.
Well, the state, that's a highly summarized statement, right? In an actual case, the state has the burden to demonstrate that the search was lawful, right?
Correct.
And the state can attempt to meet its burden any way it wants to, right?
Correct.
And the state relied on a theory of consent in this case, correct?
It did, yes.
And if, in fact, that consent was not voluntary, the state's failed to meet its burden, right?
If you don't allow additional arguments in light of intervening case law in the United States Supreme Court. What?
You want a do-over.
The case is still pending. Usually if there's an intervening change of law while a case is still pending, that applies to that case. This court permitted supplemental briefing. And
do you know of any case law in which, in an ordinary motion to suppress, the state has come back on appeal and asserted a different warrant exception, and we've allowed it to go back on that different warrant exception? Is there any case law that actually does what you're asking us to do?
I cannot think of any, no. But I think it would be reasonable to ask this court to, you ordered supplemental briefing based on Birchfield. Birchfield answers the question here, we can rely on a different exception. Or you can, if you agree with my argument in Rice, then the advisory here given was correct and we can rely on the consent
Did Birchfield
exception.
overrule any prior Supreme Court precedent?
No.
So that gets to what question I asked earlier in the prior case. Do you think Birchfield changed the law of search as incident to arrest?
I think it clarified the law, yes. This court's...
Would you agree with me that there's a difference between making something clear by giving an affirmative statement versus actually changing the law, i.e. the law was once this, and we're going to overrule that, and now the law is this?
But Birchfield did overrule this court's case. I mean...
I'm asking about the status of U.S. constitutional law.
No, there was no change in U.S. constitutional law, although it certainly changed how lower courts seem to believe.
It added clarity.
Yes.
Did it not extend the law?
It did
to
extend
circumstances beyond what we'd always what most of us had understood, the scope of a search incident to arrest and the limitations that we thought had previously been put on search incident to arrest?
Absolutely. In fact, it basically overruled portions of this court's opinion that said a search and arrest would not be lawful for a breath test. There were other courts that had basically said the same thing. They had relied on implied consent, not search and arrest. So I think it was.
But even some of the Supreme Court's own statements about the scope of what could be searched in a search incident to arrest, doesn't it extend that beyond what its previous statements had been?
I think so, yes. I mean, it went further. We didn't have a United States Supreme Court precedent that said this absolutely was a search incident to arrest, or this court wouldn't have done what it did, and well, maybe wouldn't have done what it did in Rice, and the state would have argued search incident to arrest. But when the United States Supreme Court expanded the opinion, we now want to use something that the United States Supreme Court has told us it's lawful. We would like to prove our burden now because the case is still pending, and say that search and arrest is lawful. And nothing in the rule of the exclusionary rule has changed. You just don't suppress evidence unless unlawful conduct happened, and none happened here.
Any further questions? Thank you, counsel.
Thank you.
May it please the court, Michael S. Holm II on behalf of the appellee Gregory Neese. My take is a little less ethereal and slightly more pragmatic. The court asked us to rebrief two issues because these were the issues before the court that were presented before the Birchfield opinion and before the court has already previously ruled. Number one, does the implied consent advisory properly recite an individual's constitutional rights? I went through that piece by piece in my brief. I won't bore you with it here, but there can be no doubt that it does not. It is blatantly wrong on most of the advisories that are given. So we start off with a fundamental premise that the advisories given, and essentially the foundation for the implied consent law, were both based upon erroneous interpretations and explanations of an individual's constitutional rights for a breath, blood, or urine test. So the implied consent is just flat out incorrect as applied to this case, which I explained as the court asked us to rebrief. As part of that, the court also has to bear in mind that the advisories given to an individual and the officer after arrest is given the authority to request a breath, blood, or urine test, or all three. And that's what's explained to the individual. There's no limitation on how many, there's no limitation on what type of test, and that's what's told to the individual, as it was told to Mr. Neese. And it was told to him that if he did not submit to whatever the officer wanted him to do, that would be a criminal offense. They're criminalizing somebody's ability to consent. Obviously, question answered for the first question presented by the court for the re-argument today is no, the implied consent advisories are not a correct recitation of an individual's constitutional rights. That moves on to the second question, which is again why I take a little bit more pragmatic approach. We go back to the court's original decision and the original arguments made by the state. Did the state prove that Mr. Neese gave voluntary consent? Of course not. They criminalized his ability to consent. That was a fundamental foundation for the court's decision in both Rice and in Neese. If you criminalize an individual's ability to consent, if you blatantly put in the law that you're trying to coerce them into physically submitting, and you're going to criminalize their ability not to give that consent, legal or just practical.
Is there a difference between physically submitting and legally consenting?
Yes, and I've argued this ironically all the way back since State versus Jones, which is why the state's argument that this is a brand new interpretation seems to be slightly false. Because I argued for the state back in State versus Jones, which is the PBT case, that the whole fundamental basis for the implied consent law should have been search incident to arrest. Legislature didn't listen to me, and I was arguing on the other side. State didn't listen to me. They all had the opportunity to base the law upon search incident to arrest instead. They didn't.
Have you looked at the legislative history that was being discussed in the earlier case with respect to what testimony the legislature heard when they adopted this law? The criminalization.
Yes.
What's your best recitation of the intent of that testimony? What were they saying?
I have to make sure to carefully choose my words here. I don't think they even thought about what they were doing. I think this is,
Well, do you think that they were advocating to the legislature that we really need a law that provides an incentive to individuals to lawfully consent? Or do you think they were advocating to the legislature, we really need a law that provides an incentive to individuals to physically submit to these tests?
we had a very similar conversation actually when I argued the Webb case in front of this court. Your Honor and I had this very same conversation. And it was my argument then, as it is my argument now, the legislature has lost complete and total sight of what the original purpose of the implied consent law was. The purpose of the implied consent law was exactly what we're talking about now, was to prevent an individual from physically fighting a search that should have already been done at that point in time, as a search based upon exigent circumstances. The legislature, when they passed the refusal statute, for some unbeknownst reason to me, believed that the law had changed to such an extent that it was lawful, and they already had legal consent because it was implied, as soon as the person was arrested. So all they were dealing with then on the refusal statute is to further criminalize them if they don't go ahead and acquiesce to the testing.
It sounds like you're agreeing with me that what they really wanted to do was make sure that these people physically submitted to the tests.
I have to be completely and totally honest with you, I probably do. However, I was based upon a foundation that was erroneous, and their foundation was they already believed they had a legal search in it anyway as soon as that person was arrested due to exigent circumstances, which was wrong. And so this gets me back to, again, me being very pragmatic on this. The whole reason we keep on having these arguments and these issues, and Birchfield exist, and now Neese and Rice, and all these problems, Webb, all these cases, is because of the fact that the entire foundation for the implied consent system was based upon an erroneous assumption of the law, which was search incident to arrest, and everybody's lost sight of that. And that doesn't exist anymore. This is kind of like trying to operate a very complicated modern day software system on an Apple IIe. And I'm old enough to remember what an Apple IIe is. It wouldn't work. It's the same problem we've got now. We're trying to operate a very complicated arrest system for DUIs and implied consent advisories is based upon a very antiquated system based upon something that doesn't even exist as a fundamental basis anymore. And so if the legislature would actually listen to the people who practice law in this area every single day, they would do away with it all. Just arrest the person like they would in any other criminal case. Say, hey, you want to take a breath test? And 99% of the time they would. If they want to impose administrative sanctions on their licenses, if they don't, they're free to. That's separate. The Constitution doesn't apply. It would be that easy.
And Birchfield now says definitively they could also criminalize that refusal to physically submit.
That's true. But that's not what our law is premised upon, so we get back to being pragmatic and just dealing with the issue at hand right now, which the issue in hand right now is the state below on appeal, and even afterwards until Birchfield came down, has only argued consent.
Would you agree or disagree with this premise? If the Kansas law criminalized the refusal of an individual who was under arrest to physically submit to a test, if that's the status of the law, and I understand you say it's not, do you agree that then that your client's consent was voluntary because the advisory he was given was actually accurate when it said you can be charged with a crime?
No, because that's a different type of consent. That gets us back to the first conversation. That was the whole purpose of the implied consent law. We're going to coerce a person into physically acquiescing because we can already do the search anyway.
So your argument is that regardless of the status of the underlying criminal statute, your client never gave consent, period.
Yeah, because he's threatened with things. You can't threaten an individual with something and actually ask for voluntary consent free of duress or coercion. If you want to apply that exception, the consent exception, that's fine, but get rid of all the coercion. If you don't want to apply that exception, then you have to get rid of all the law, go back, rewrite it as a search incident to arrest law, and do it the right way. You cannot keep using an Apple IIe to operate a modern day system where it has no application. You're going to keep on having these complete and total meltdowns. And I'm going to keep coming back and arguing in front of you again, because that's what my job is. But as of just a simple issue before the court right now, Search incident to arrest was never argued. Lack of the exclusionary rule applying to legislative actions was never argued. Only thing they chose to argue, they hung their hat on, and now the boat is sunk, was voluntary consent or consent, legal consent, based upon an interpretation of the Kansas implied consent law. This court has already ruled on that. Birchfield does nothing to change that. So based upon that, based upon their own arguments, this is the status of the law, and all we can hope is that the legislature listens, throws the whole thing out and starts over again, and actually bases it upon a solid legal foundation and not just piecemealing things based upon political whims.
Counsel, there was discussion earlier with opposing counsel about whether Birchfield added clarity or whether it extended the law. What is your position on that?
It added clarity to why the United States Supreme Court believes it does not violate an individual's Fourth Amendment rights to ask them to submit to a breath test and theoretically to criminalize their physical refusal to do so. I respectfully, very respectfully disagree with the United States Supreme Court on the fact that they seem to imply that this is what they've always said. It's been difficult. I don't believe they changed anything. The only thing I do believe they did, ironically, is expand the protections for blood tests. They also didn't talk about urine tests, which I believe should be treated the same as blood tests. So we know we have extended provisions that apply now to blood tests and to urine tests. We know now that pre-arrest testing, because it wouldn't be a search incident to arrest unless you come up with some other exception, such as PBTs, which is relevant, would also be unconstitutional. So it clarified both of those two things and actually added extra protections for blood tests and urine tests that didn't exist anymore. I don't think it changed anything fundamentally, which I've been arguing. You can look at my brief in Jones. I don't think it changed anything fundamentally about what the real constitutional basis is for breath testing. It should never have been exigent circumstances unless there are exigent circumstances. But there was always an argument to be made that was search incident to arrest. The state just has never made it. If that answers your question.
It does. Do you have any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
If this court finds that the criminal refusal statute criminalizes refusal, then everything told to Nice in this case was in fact accurate. And it's not coerced consent, it's informed consent. We can tell you what the legal consequences of your actions are going to be.
How is it not coerced?
In the same way that when we say, we can go get a warrant, would you like to see
I
to the
understand that
search?
some of our prior case law has said, well, it's sort of tried to straddle a line. It said, yeah, it's coercive, but it's not coercive in a manner that would render the consent involuntary. That seems to me to be splitting the hair of coercion pretty fine. If you tell somebody, even accurately, you're going to be charged with a crime if you don't consent. I have a hard time understanding how that's anything other than coercive.
It's not unconstitutionally coercive. It may be coercive in day-to-day speech, but not unconstitutionally.
So then help me understand the difference between day-to-day coercion and unconstitutional coercion.
Unconstitutional coercion is if the law doesn't permit it. We are legally permitted to do all of this.
We're here talking about what the law is.
Correct.
And the result of this case might further elucidate what the law is. The root issue is voluntariness of the consent. Well, the root issue is consent. And for consent to be valid, it has to be voluntary. And the sort of exact opposite of voluntariness is coercion. And I understand you to say it's day-to-day coercive, but it's not unconstitutionally coercive. And I don't know the difference between those two things.
What I mean by day-to-day is like when you tell your child or something, if you don't do this, this is the punishment. Someone might consider that under the word coercive and the everyday language coercive, but not legally coercive. It's not unconstitutionally coercive to tell your children, this will happen if you don't do what I tell you to do. The same is here. We can tell the defendant, the law says this is what will happen if you don't refuse.
I understand
Or if you don't
that. I
consent.
guess we're talking past one another. Why isn't the law itself coercive? Set aside what he gets told. Why isn't this criminal statute coercive?
The existence of it. You're splitting accuracy from coercion, I think, in your argument, aren't you? You're saying what we told him was accurate, right? This
I don't
is what
understand
the law
how-
provides.
Correct, but I don't understand how telling someone what is legally accurate can be unconstitutionally coercive. I guess I don't understand the question, maybe, or how you can get there.
Well, again, this goes back to kind of a fundamental confusion in these cases. What are we coercing? It can be, coercion is not permitted if it is used to obtain an involuntary legal consent. That's what the case law says. But coercion, law enforcement uses coercion all the time. Lawful coercion to force physical submission.
And
Isn't
here-
that the difference, really?
Correct. We're using lawful coercion to get them to go along with our test.
Well, but that's not the theory that was presented in this case. The theory that was presented in this case by the state is we used lawful coercion to compel this individual to give his legal consent. And that's different than what law enforcement does all the time, which is coerce individuals to submit, lawfully submit. And it's lawful coercion. Do you see the distinction I'm drawing?
Not really. I mean, I understand what you're saying, but the distinction seems to me to be splitting hairs. If we
The
can-
reason it matters is because the defendant, pursuant to the state's theory, the defendant voluntarily gave up a constitutional right. And that's why it matters, right? Because the state cannot impermissibly coerce an individual into voluntarily giving up a right that the Constitution grants.
Coercion and voluntariness are incompatible. Logically and legally incompatible. That's what you're saying. Would you agree with that? Coercion and voluntariness. And if the state's whole theory was built on voluntariness, which it was, right? Up till this point. Would you agree with me that
I would
far?
agree with you on that.
Okay, we're just getting that piece out of the way. Okay. Is voluntariness conceptually consistent with coercion?
Yes, if your theory is that, I mean, there are levels of coercion, I guess. And I'm talking about unconstitutional coercion. And I'm not aware of any cases ever found if you lawfully tell someone the consequences of their actions, thus making them have what I would like to call informed consent. Sorry.
Well, it sounds like you're arguing that the state is permitted to coerce a little bit an individual into giving up his constitutional right.
As long as the coercion we're using is lawful, yes, we're absolutely allowed to do that.
So some coercion is lawfully permitted to be used to compel an individual to forfeit a right.
Yes, as long as what we are doing is lawful, we can. I don't know that you're forfeiting a right. You can still say no. We're just telling you there will be consequences. We're giving you information about whether or not you want to comply or not. I think it's this court that in Standish, I believe, that told the state that it has to start doing what we now have in KSA 8-1001K, that we need to tell them what their rights are. We don't do that in other criminal cases. We just flat out ask for things and then it happens.
Is there a right to refuse to submit to a search incident to arrest?
No. But in the breath test world, you can say no and you can kind of refuse. And
there are
we can't force you,
consequences
but there
for
are
that.
consequences for your refusal. If there are no further questions, the state would respectfully request you reverse the district court in this case.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.